Hi, welcome to Buckhalter's Lions and Tigers and Bears Oh My, Insolvency Reality. My name is Daniel Slate. I'm a partner in the Insolvency group here at Buckhalter. With me is Brian Harvey, a senior counsel in the Insolvency group, and Reed Mercado, who is in our commercial finance department. A word of explanation about the title is come to my attention that the reference to Lions and Tigers and Bears Oh My is a generational thing, and apparently children have not seen the movie The Wizard of Oz. Nevertheless, that's what it's meant when Dorothy and the Scarecrow and the Tin Man are wandering through the forest and it's getting scary. That's where we are today in June of 2020, when the New York Times has an article today that talks about the tidal wave of bankruptcies that are coming. We think that that's the case, and we understand that there are many people who are involved in special asset situations who may not have had the familiarity and the experience of bankruptcies and insolvencies, and this is hopefully just a class that helps you get started in that direction. Overview. We are going to be talking about three different concepts primarily. One is the pre-negotiation agreement, which we are all enthusiastic about getting done, because if you don't have a pre-negotiation agreement, you can get chaotic and confused. Assuming that you enter into a pre-negotiation agreement, the next step would be to work toward a forbearance agreement. Reed is going to talk about both the pre-negotiation agreement and the forbearance agreement. And then the third area is what happens when those things don't work according to plan. What are the alternatives? And we'll be talking about out-of-court workouts and bankruptcy, and that'll be Brian and me.
Great, thanks, Dan. This is Reed Mercado, and talking about pre-negotiation agreements, they are exactly exactly what they sound like. It's an agreement that between a lender and a borrower when they are executed at the commencement of negotiations, if there's been a default under the loan documents, and as Dan says, it's so no one gets confused, right? And typically these negotiations occur over a period of time. Not everything is agreed to at once. You can perhaps agree on one issue and then not another. And so a pre-negotiation agreement, and at its core, essentially just says the parties agree that there will be no formal deal, workout or otherwise, until all of the documents have been finalized, an agreement is reached on all issues, and the documents are signed. That is sort of the core of the document. There are several other features that are commonly included. For example, as indicated on the slide, if there's additional reporting that's required, oftentimes a lender will want to see a borrower's updated budget by a certain date. You'll include that deadline and requirement in this pre-negotiation agreement. You'll also rehash to a certain extent and specify what the obligations are of the loan parties to cooperate. That's usually set forth in the loan documents, but you can expand upon that and reiterate it in your pre-negotiation agreement. And then the last piece that I often like to include in them is conditional language, right? It's just the out for either the lender or the borrower, and essentially, add language that said on the lender side, that the bank's going to be conducting ongoing due diligence and review, not only of the borrower, but of general market conditions. And the bank can stop negotiating at any time and for any time, and that no one is obligated to enter into any agreement as a result of any agreement formalizing the workouts that's being discussed based on these negotiations.
One of the things that I like to see in a pre-negotiation agreement is confirmation that we're going to be going down parallel paths. we're going to talk about a resolution, but we're also going to be going forward and exercising rights and remedies if that's a path that is to the benefit of the creditor. And without a pre-negotiation agreement, you end up getting a, wait a minute, you promised you wouldn't do those things. I assume you deal with that, Reed?
Yeah, absolutely. That is a very good point that Dan brings up. If the issues have, if the default's been going on long enough, the dispute, so to speak, between the borrower and the bank has been going on long enough, and the bank is already in a position to start exercising remedies, it will be pursuing dual paths, and you will want to set that out to avoid any claims of, I guess, bad faith or unreasonable practices on the part of the bank. As indicated on this next slide, diligence, very important in terms of for pre-negotiation. Before you're doing your pre-negotiation agreement, very often, as Dan mentioned in the intro, you'll be entering into these agreements in connection with a transfer from the loan officer that has a long-standing relationship to the borrower to a SAG group, to a different officer in charge of the default situation. And there's often, it's very important, in my experience, to not only review the email exchanges between the loan officer and the borrower, but also just conduct an interview of the loan officer with the new SAG officer taking over, and get an idea of what the communications have been to date. Try to figure out if any promises that are not in writing have been made, so that you can really know what you are walking into before you start either documenting a forbearance or other workout agreement or exercising your rights and remedies. Similarly, you'll review the loan documents, see if there's any gaping holes in them. You'll check to make sure liens are perfected. And the results of that diligence really dictates, for me at least, the tone of the document. If you've got course of dealing issues, perhaps holes in your documents, collateral you need to take possession of in order to be perfected, I'll typically use a more folksy format, so using I and you and we instead of defined terms. Or if everything's, if all the bank's got all its ducks in a row, then, you can take a harder stand and make it a more formal document.
This is the time when I got a telephone call from a banker one time that said, Dan, what's the likelihood of success to sue on a guarantee that was supposed to have been signed? You want to know that before you get too far downstream.
Absolutely. And here's my last point on pre-negotiation agreements is your guiding principle. Hogs get fat, pigs get slaughtered. Really just a reminder to not overreach in connection with this. It's really just an agreement to negotiate. And so I've seen instances where banks will try to extract a release of liability from the borrower. That's a really bad look if it winds up in front of a judge and the borrower says, well, Your Honor, we wanted to negotiate with the bank, but they wouldn't even talk to us unless we gave up all of our potential claims against them. And so, again, it's more art than science. It's a delicate balancing act, but at the end of the day, these are intended to be short agreements, and so you don't want to overreach too much.
And Reed, before you, that's a good point, because every piece of paper, once there's a defaulting situation, you need to assume that there's a high likelihood that a judge is going to look at it. And you don't want that judge to look at it and then look at you askance. You want the judge to look at it and go, hey, these guys were reasonable people. They tried to work it out. So that's the appearance that you need, that I think you need to get in the pre-negotiation agreement and also in the forbearance agreement. You want to have the appearance of reasonable. You tried hard, it didn't work.
Absolutely, and a lovely segue into the next topic of forbearance agreements. Typically, these will follow your pre-negotiation agreement, the negotiations that are the subject thereof. A forbearance agreement, again, is exactly what it sounds like. There's been some sort of default under the loan documents. The lender is going to forbear from exercising its rights and remedies in respect of that default for a defined period of time or until some determined conditions occur, like a new default. But in the meantime, they are going to reserve all of their rights and remedies with respect to that, so that when any of those conditions, either the passage of time or the occurrence of a new default occur, the lender has reserved its rights and it can begin exercising its rights and remedies. This is obviously distinguished from a waiver of any defaults that have occurred. It really just needs to be one or the other is really the point here. You don't want to be in a situation where a default is just ignored and you enter into a new document. You really always need to address it either in the form of a forbearance or a waiver. And then eye on the prize, I've got this down as simply means, keep perspective. As the attorneys, our job is going to be to make it as easy as possible on the lender when and if it has to exercise remedies, which means fixing documentation issues, including self-serving facts in the documents that will help in the event of litigation or bankruptcy or foreclosure, and thinking through as many of the pitfalls as possible. I really like to dig into the specifics of each borrower with my lender clients when I'm doing this, figure out what it is that they're going to need in order to successfully exercise their remedies, realize on collateral. For example, if the lender has limited visibility into the borrower's operations, I've incorporated into forbearance agreements a requirement as a condition of closing that the borrower give the lender read-only access into its billing systems. And so the lender can actually see what's going on a day-to-day basis. It can't change anything or do anything, but it has the ability to monitor it. Those are the sorts of issues I always try to keep in mind on a more global level when I'm doing a forbearance agreement. So the primary components of a forbearance agreement, I include very detailed recitals that establish the universe of the documents, like your signed guarantees, as Dan mentioned, so that, again, if you wind up in front of a judge and the borrower is arguing about a guarantee wasn't signed or a subordination wasn't signed or anything like that, you can always pull out your forbearance agreement and say, well, Your Honor, no, that's not quite right. But they acknowledged right here after a default had occurred that this document did in fact exist. In terms of the forbearance itself, you want to be very specific, make sure that it's generally forbearing with respect to particular specified defaults. If you're going to preserve the right to actually exercise any rights and remedies, for example, imposing the default rate, you're going to want to build that in and call that out. The other thing, as Dan had mentioned, in terms of going down dual tracks, I always like to make it clear that while the bank is forbearing, it is going to take the steps it needs to take in order to be ready to foreclose at the end of the forbearance period. And so while it won't complete a foreclosure action, it will process it and take whatever steps it needs to. During the forbearance period, you're going to correct any mistakes. And as an acknowledgement to set up an estoppel, similar to the point I made with recitals, you want the borrower to acknowledge the amount of the debt, that it has no defenses, all of those sorts of bells and whistles that will make life easier for the lender in the event that it winds up in litigation with the borrower. Here, as opposed to the pre-negotiation agreement, absolutely get a general release of liability. That is very important to clear out any claims. Common features of forbearance agreements: there's typically a budget attached to it, and there will be increased reporting throughout the forbearance period. And so if the results of the borrower's actual operations don't match its projected budget by some set variance amount, the forbearance period can terminate. You also can, as I mentioned, include some self-serving facts that will support a relief from stay later down the line if the borrower files for bankruptcy. You can include post-default UCC waivers, for example, the waiver of the notice of sale, waiver of the right to redeem, a waiver of the notice of a partial strict foreclosure, those sorts of things. You also get a chance to include another post-dispute jury trial waiver, which is important in jurisdictions like California where pre-dispute jury trial waivers are not enforceable. I'm not sure if a judge will waive a jury trial based on this. It's not been my experience, but it's always worth getting in there. And that, gentlemen, concludes the first two topics of the presentation.
Okay, we're moving on to out-of-court workouts. Before we get there, one of the terms that is not uncommon in a forbearance agreement is a consent to relief from the automatic stay, or some acknowledgement that the creditor is not adequately protected and is entitled to an order, all those kinds of things. We went back and forth about whether or not to include that in the forbearance agreement, and the collective wisdom here is that it doesn't do much good, and it could harm you if the bankruptcy judge feels that his or her discretion is being taken from him or her. So just a word of caution. You write every document as if the judge is going to read it, and you don't want the judge to have a nose out of joint because of some provision in an agreement that the judge may think is a little bit overreaching. All right, out-of-court workouts. Why do an out-of-court workout? Well, one is that it's a liquidation that can realize assets much more quickly if it's done right. Two is the administrative costs, for example, attorney's fees, can be substantially lower. And three, if the assets are dissolving in value, it may be the best way to maximize value. The easiest example of an out-of-court workout would be one where there is a universally acknowledged best path to maximize assets and to resolve the creditor claims, but that requires some involvement of an out-of-court. So if we could move the next slide, please. There are several alternatives, and it really depends on how best you want to move this thing forward. One would be just a coordinated sale with creditor support, but the debtor's managing the disposition. If that's not an option, you may move with a wind down, but with the debtor running the wind down, or a debtor representative, the debtor chosen representative. And that presupposes that the debtor is a mostly honest individual. Moving down that path, the next would be an assignment for the benefit of creditors, an ABC. The debtor signs a piece of paper transferring all of the assets to an assignee, who then manages the liquidation, the disposition of assets, and then makes distribution. Step further along in the complicated path is a state court receivership. That involves the filing of a state court lawsuit, and typically by the secured creditor who wants to preserve the assets while it proposes to dispose of its collateral. That's a challenge and complicated, and it depends on the jurisdiction. In some courts, that's not an easy path to take. So if we assume that those are all exhausted alternatives, another path that may make things faster is you negotiate the terms of a plan before you go into bankruptcy, and you tie the constituent creditors up in some sort of support agreements, and then you go into a bankruptcy case and then effectuate that negotiated resolution. And a further step would be a prepackaged plan where you not only negotiate the terms of a deal, but you actually solicit acceptances to that deal. And then when you file the bankruptcy case, you walk in on day one and say, here's the petition, here are the schedules, here's the plan, here are the solicitation materials, here are the consents to the plan, please schedule a confirmation hearing. That's a pre-pack. Those are challenging things to get done, and it assumes that creditors are behaving themselves and not taking steps that are self-interested at the expense of the creditor body generally. If we can go to the next slide, please. So why isn't an out-of-court workout always done? Well, an out-of-court workout requires two very rare characteristics. The creditor body has to cooperate in a broad, general way. And that means they all have to take the collective approach instead of the individual approach. You don't want to you don't want to encourage creditors to race to the courthouse. And if one creditor gets an attachment, for example, and is trying to lever himself above or herself above others, that's a problem. The second characteristic that unfortunately doesn't happen often enough is you need an honest debtor. Out-of-court workout is dependent upon trust. And if you can't trust the debtor to behave in a way that they say they're going to behave, then you got to go in and get a court order. But and sometimes, by the way, even though theoretically the path is quicker, sometimes the parties negotiate, the term we use here is dither, back and forth trying to gain leverage. I had a state court receivership a couple of years ago where it took us 2 months to agree on the identity of the state court receiver. Setting aside the asset disposition, we couldn't agree on who was going to manage the process. And it was sort of, I brought this guy, you brought that guy, I want my guy, I don't want your guy. And that kind of stuff stalls cases, and it needs to be avoided. Then the other thing that is sometimes an impediment is when you can agree on the process, but you can't agree on the exit. One creditor group wants a sale of a going concern, so you got to keep the business operating. Another one wants a liquidation. Let's just close the business down and sell it piecemeal. If the constituent groups can't agree, that causes a delay that also, frankly, impacts on the value from an out-of-court workout. Okay, so we're going to assume all those things fail. And now we're in the wonderful world of bankruptcy. Just a word, and excuse us for being very general and simplistic. There are several chapters in bankruptcy. The primary chapters we're going to talk about are chapters 7 and 9 and 11. Unless there are any farmers in the community, they want us to go into 9, which I don't think we want to do. That's 12. Never mind. 9 is a city, is a municipality. But chapter 7 is a liquidation, and chapter 11 is a reorganization. In either case, at the beginning of the case or early on, they file some interesting papers. The petition, of course, which is the thing that initiates the case, the bankruptcy case, they file a schedule of assets and liabilities, which is ostensibly a balance sheet. If you can imagine, you're sitting there quietly at your desk, and all of a sudden you're responsible for a boatload of assets and liabilities of a company you've never heard of. The schedules are what are given to the bankruptcy trustee to educate that trustee as to what assets need to be managed. It lists everything, every supposed asset and every supposed liability. The Statement of Financial Affairs is another document that they file, which goes into some historical reference, payments made within 90 days or within a year if you're an insider. For some reason, they don't trust lawyers, so they want to know what lawyers have been paid, who the accountants are, what bank accounts they had, who got financial statements, those kinds of things. That's in the SOFA. All those things are interesting historical documents. They don't necessarily help realize value, but it may help explain how the debtor got to where it is. Next, please. Brian, why does somebody really need to file a bankruptcy when they need to file a bankruptcy?
Thanks, Dan. Well, the very first thing that's going to happen when you file a bankruptcy case is that the bankruptcy automatic stay is going to go into effect. And the bankruptcy stay is effectively a court injunction that's imposed by the bankruptcy code. It prohibits any act to collect on any debt of the debtor, including litigation or a pending foreclosure proceeding. And another interesting thing about it is that acts that are taken in violation of the stay are considered void, meaning that even if a creditor does not receive notice of the bankruptcy filing in time to stop a foreclosure sale from proceeding, if the foreclosure sale does go forward, that act is considered void and has no legal effect. So one of these things to keep in mind for financial institutions that it doesn't require the debtor to bring it to the attention of the foreclosing creditor. Does not require them to take any act in the bankruptcy court to set the sale aside, although they often will. The act is considered void regardless of whether the debtor takes any affirmative action. Another thing to keep in mind is that in addition to the act being void, any act that's taken in willful violation of the automatic stay can subject a creditor to sanctions. Section 362K of the Bankruptcy Code provides bankruptcy court with authority to issue sanctions against the party that violates the automatic stay if it makes the determination that that violation was willful, meaning that if the creditor knew or should have known that the bankruptcy stay was in effect, but proceeded regardless, it will be considered willful and it can lead to sanctions. Sanctions can include actual damages, attorney's fees, punitive damages. There's a pretty famous case from 2017 where a California bankruptcy judge sanctioned a major financial institution for violation of the stay and awarded $45 million in punitive damages. So it's definitely something that every creditor needs to immediately keep in mind. And the minute that you receive notice of a bankruptcy filing, you need to stop everything you're doing and consider whether or not that would be considered a violation of the stay. Of course, there's always unique situations, and it's going to be unclear whether or not a certain act would violate the stay. My general advice to clients is that in those circumstances, to seek relief from the automatic stay from the bankruptcy court first. It's always better to err on the side of caution. Typically, filing a motion for relief from stay is always cheaper than defending a motion for sanctions if the court or somebody objects to the act that you've taken once the bankruptcy case has been filed. So,
hey, Brian, Brian, with respect to that, if it's an action you want to be taking and you want to make sure that it's not violative of stay, you can still you can impose an administrative hold to preserve status quo, right?
That's absolutely right. So I was going to talk about that in just a sec, but we can jump ahead. So Section 553 of the Bankruptcy Code is of particular importance to financial institutions because that code section preserves the right of set-off in a bankruptcy. So for a depository institution where they have a borrower or a guarantor who has funds on deposit with the bank, that code section permits you to offset that mutual obligation. But it creates an interesting dilemma because getting back to the automatic stay, that prohibits a bank from taking any action to collect on a debt. But at the same time, you've got Code Section 553, which authorizes and preserves the right to set off. In addition to that, there's another code section, Bankruptcy Code Section 542, which places an affirmative obligation on any party that's holding property of the debtor, which is considered property of the bankruptcy estate that's created when a bankruptcy case is filed. Section 542 places an affirmative obligation on those parties to turn over any property that you're holding to the debtor or to the bankruptcy estate. So what's a creditor to do, particularly a bank that has a deposit account where they want to assert their set-off rights? Well, there's judge-made case law that says that you can temporarily place an administrative hold on that account to prevent the debtor from withdrawing the funds, but it's not indefinite, and you have to take prompt action to then seek relief from the bankruptcy stay in order to apply the set-off and use the funds to pay down the outstanding obligation. So
just a word of caution on that. You know, it may be that you have a right of offset, and it may be that in order to avoid violating the one action rule under California law, which is beyond the scope of this conversation, you may not want to take that offset right. But we're talking about what you can do, not what you should do here, right?
Absolutely, and that's a very good reminder. So for purposes of obtaining an order lifting the automatic stay, Section 362D of the Bankruptcy Code lists out various arguments and grounds under which the bankruptcy court can lift the stay. The two most common are under D1 and D2. D1 is for cause. A typical example of the court granting relief from stay for cause would be a lack of adequate protection of a lien holder's interest. So consider an instance where the collateral value is declining post-bankruptcy. A very basic, easy example is to think about a car loan and with cars that are depreciating on a daily basis as they're being driven. So if your inventory levels are declining, if the value of real property collateral is declining, if accounts receivable is being collected and spent and not replaced with new accounts receivable, so any instance where a creditor can demonstrate that the value of their collateral is declining, that would create cause for relief from the automatic stay. Then the second typical or most common grounds for relief from stay is under Section D2. The argument there is that the collateral, the debtor lacks equity in the property and that it's not necessary for an effective reorganization. In Chapter 11 reorganizations, which we're going to discuss in a little bit, it's almost always the case that the debtor's primary assets are considered necessary for reorganization. So this grounds for relief from stay typically only applies in Chapter 7 liquidation cases. And all the creditor would need to demonstrate is that the property is underwater, that the amount of the debt is greater than the value of the collateral, and that it's in the case of a Chapter 7 case, it's a liquidation case, and so there will be no reorganization. And in that circumstance, the court should grant you relief from stay. One last thing to think about for motions for relief from stay is potentially requesting an annulment of the stay. Getting back to what we were first discussing, which is the possibility that an act was taken in violation of the stay without the creditor realizing that the bankruptcy case had been filed. That act would be void, but you could subsequently file a motion to annul the bankruptcy stay, and this gives the judge the ability to wave the judge's magic wand and to annul the stay effective as of the date that the act occurred, rendering it not void and legally effective.
Well, circumstances where you would want to exercise that is if, for example, you recorded a notice of default after the bankruptcy but before you knew about it, and then you go in and seek relief from your automatic stay, you could get the stay annulled so that your recorded NOD would still be effective and that 90-day clock would continue to run.
That's right. That's a great example. Next slide. Okay, so this slide lists just a couple of the events and certain deadlines that will occur in every bankruptcy case, or almost every bankruptcy case. The first one, the 341A meeting of creditors. In every bankruptcy case, the U.S. trustee's office will hold a meeting where the debtor, if it's an individual, or a principal of the debtor, if it's a company, will come in and be placed under oath, and will have to answer questions on the record regarding the reason why the bankruptcy case was filed, if it's a reorganization, how the debtor intends to reorganize its obligations and emerge from bankruptcy, and also answer questions regarding its assets and liabilities, information that is contained in the schedules that Dan was discussing earlier. It's also an opportunity for creditors to come in and ask questions of the debtor or the debtor's principal under oath. So think of it as a brief and free deposition. One thing to keep in mind is that oftentimes, particularly in a Chapter 7 case, the U.S. trustee will not give you very long to ask questions. So it's a useful tactic in certain cases, and in others, it's not worth the expense of attending. The claims bar date. Most of you probably are familiar with this, but in most bankruptcy cases, the court will set a deadline for filing proofs of claim. all this is a piece of paper and supporting documentation that gets submitted to the bankruptcy court that asserts the fact that an obligation is owed to a particular creditor and the dollar amount for that obligation. And then you're supposed to attach any documentation that supports it. So for instance, a promissory note or unpaid invoices, things of that nature. Avoidance actions, we don't really have time to get into those in detail here, but the two most common would be fraudulent conveyance actions. Those would be lawsuits that would be filed once a bankruptcy case is commenced with the bankruptcy court, seeking to set aside a transfer of the debtor's assets that occurred pre-bankruptcy. And then the second most common form of avoidance action that many of you may have heard of would be preferential transfer lawsuits. And these are lawsuits that seek to avoid payments that were made to creditors on pre-existing obligations leading up to the bankruptcy case being filed. For ordinary creditors, the time period is any payment on an existing debt that was made within the 90 days before the case was filed. And then for insiders of a debtor, so think about the debtor's owners here, the look-back period for avoiding a preferential transfer is 1 year prior to the bankruptcy case being filed. And then the last thing here is objections to discharge. For financial institutions, particularly commercial lenders, this would only really come up with regard to potential guarantees that you may have. And if one of your guarantors filed for bankruptcy, the court in individual bankruptcy cases will set a deadline for filing a complaint objecting to a debtor's personal discharge. So the common ground for that would be some sort of fraud. And in the case of commercial loans, we've prosecuted objections to discharge for things like fraudulent borrowing-based certificates being provided by the borrower to a bank. And then when the guarantor, the owner of the company, files his or her own personal bankruptcy case, then we can object to that, to the discharge of the guarantee on the argument that the owner was part of the fraudulent scheme in providing the things like a fraudulent borrowing-based certificate or false information at the time of the loan application. Next slide. Okay, so next we're going to focus on Chapter 11 and Chapter 11 reorganizations principally. Occasionally a Chapter 11 case will be filed where the intention from the outset is to still liquidate the debtor's assets, but the most common thought of type of Chapter 11 case is the Chapter 11 reorganization. And the assumption, the working assumption at least here, is that the continued operation of the debtor will lead to a greater recovery by creditors, and with the added benefit that it would also potentially preserve jobs. So unlike a Chapter 7 case, which is liquidation, when a Chapter 11 case is filed by an operating business, a trustee is not appointed. The debtor remains in possession of its assets, and is referred to as a debtor in possession. Sometimes you'll see this written out as a DIP. And the bankruptcy code in a Chapter 11 reorganization where you have a debtor in possession authorizes that debtor to continue to operate in the ordinary course of business. So all transactions that would be considered within the ordinary course, the debtor can continue to carry out those transactions without seeking bankruptcy court authority. But anything that would be considered outside the ordinary course, so for instance, if we're thinking about a retail debtor, the debtor can continue to make sales at a store location, and that would be considered an ordinary course transaction where each individual sale to a customer does not require the debtor to run into court and bankruptcy court approval. But if the debtor wanted to sell all of its inventory in bulk, that would be something that would be considered outside the ordinary course of business. And so all outside the ordinary course of business transactions of that nature would require the debtor to file a noticed motion to put all of the creditors on notice of what it's trying to do and then to obtain bankruptcy court approval. We go to the next slide. So this slide lists various elements of the administration of a Chapter 11 case. The very first thing that's going to happen in a Chapter 11 reorganization is that the debtor will file what are referred to as first day motions. So to common examples of first day motion. Oftentimes, there will be a number of affiliated companies that will file bankruptcy together on the same date. So one of the very first day motions that you will see is a motion for joint administration. What that's asking the court to do is to keep all of the affiliated entities together, and at least for administrative purposes, in one bankruptcy proceeding where there will be one bankruptcy court docket, despite the fact that there's multiple debtors, multiple companies that have filed different cases. And for all of those cases to be heard before the same judge. It's just for administrative ease for all of the parties involved. Another common first day motion would be a cash management motion and a motion for authority for the debtor to maintain its existing bank accounts. Usually, a debtor is obligated to create new DIP accounts, but for certain companies, that's just not a feasible thing to accomplish. And so the debtor will file a request to be excused from that obligation where they can maintain their cash management system and their usual accounts. Another example would be a motion to require utility providers to continue to provide utility services to a debtor. Oftentimes when a debtor files for bankruptcy, they're behind on their utility bills. And in order to prevent the utility providers from turning the lights off, the debtor will file an emergency motion requiring the utility provider to continue to provide services. In return for that, the Bankruptcy Code requires the debtor to demonstrate to the court and to the utility providers that they will be adequately protected going forward in the bankruptcy case and that they will be paid for the services that they provide post-bankruptcy.
Not to suggest that the fix is in, but it's very common in first day motions. The judge will be handed a book of 500 pages of various first day motions, and they're all along the lines that Brian was just discussing. The one that I find most interesting is the declaration of the CEO or the chief restructuring officer or whoever's running the show on the debtor side, because that is the evidentiary support for all the other motions. And so if you're not familiar or you want a primer on what this case is all about and how this case got to where it is, that declaration is the thing you read. The rest of it is just legal mumbo jumbo, I think, fairly.
That's right. And these motions are almost always granted on an interim basis. The judges are asked within a matter of 24 to 72 hours to rule on these motions, because there are many actions that the debtor cannot take until they have an entered court order approving it, and the lights have to stay on, employees have to go to work, the business needs to keep operating. So these motions are typically granted on an interim basis and then continued out to about a month and a half later, where there will be a continued final hearing. And at that point, all of the parties involved and the judge will have had a better opportunity to read through everything and to file oppositions if warranted. Two other common first day motions, just quickly to touch on, is a motion for post-petition financing. So, a DIP lender and the debtor seeking approval of a loan agreement to provide financing post-bankruptcy. We don't have the time to go into that today. We could do an entire program on DIP financing and DIP financing agreements and what is and is not allowed in a DIP financing agreement. But that is a common first day motion. And the last one, which I'll briefly go over, is a cash collateral motion. And this is something that most financial institutions who provide secured loans are likely familiar with. Cash collateral is the revenue that's generated from the sales of inventory or the collection of accounts receivable to assets that typically financial institutions will hold liens on. And the debtor is prevented from using that cash collateral under the Bankruptcy Code unless one of two things happens. The lien holder either consents or the bankruptcy judge gives them authority to use the cash. So this typically leads to an opportunity very early on in the case, hopefully before the case is filed, for the lender and the debtor to negotiate a stipulation that authorizes the use. Bankruptcy judges are almost always going to authorize initial use of cash collateral at the very first hearing. And so it's a good opportunity to enter into an agreement that provides certain protections to a bank's interest in exchange for the debtor being able to use that cash to continue to operate. A couple of common forms of adequate protection in a stipulation would be an operating budget that caps the amount of the cash that's coming in the door that the debtor can use, and replacement liens on assets that the debtor would acquire post-bankruptcy. And then the last thing, if you can get it, would be adequate protection payments, typically in the form of interest-only payments. The next thing on this slide would be executory contracts and unexpired leases. An executory contract is, in its simplest definition, a contract where there are obligations owed by both parties that remain to be performed. A typical example, I guess, would be a software license or perhaps a trade agreement. So the debtor early on in the case is going to have to make a determination on whether they want to assume or reject executory contracts and leases. For leases, the deadline for the debtor to make that decision would be 210 days from the date the bankruptcy case is filed. The ability for a debtor to reject leases is one of the best tools that, for instance, a retail debtor has going into a bankruptcy case. It allows them to downsize, to shed unprofitable, non-performing stores, to reject those leases, and then to reorganize around the core performing stores that are profitable. And then quickly, the last thing on here is the monthly operating reports. So every corporate debtor is going to be required to file a monthly report with the bankruptcy court. It's a public record that all creditors can pull up and look at. It's due on the 15th day of the following month, and it provides very useful information for a creditor to be able to monitor where the case is heading and the prospects for the debtor to successfully reorganize. The monthly operating report will include a profit and loss statement, a balance sheet, and will have a value of the current accounts receivable. Next slide. So
is this me?
I'm going to turn this over to I'm going to turn this over to Dan, who's going to cover Chapter 11 plans of reorganization.
Yeah, in the next 5 minutes, we're going to talk about confirmation of a plan, which is, of course, the goal of a Chapter 11 plan, Chapter 11 case, and something, frankly, that some judges take pride in facilitating, rightly or wrongly. The debtor has exclusive right to propose a plan for the first 120 days. You can try to shorten that time or lengthen that time for cause. Some judges have an attitude that if somebody wants to propose their own plan, that isn't cause to extend the time. It isn't cause to shorten the time. Give the debtor the time. Next, please. What is a plan? A plan is the functional equivalent of a contract between the debtor and its creditor body. The difference with a contract, however, is this can be binding on creditors who haven't consented. And so the confirmation process has some checks and balances in it designed so that if a creditor should economically support a plan but chooses not to for reasons of trying to be punitive, for example, against the debtor, nobody does that to me kind of thing, then the plan can get confirmed over the objections of the creditors. The plan puts every creditor into different classes, and the classes have to be functionally equivalent types of classes. Secured creditors are normally in a class, each secured creditor is in a class of its own, primarily because their priorities are unique. And then it also identifies classes of claims that are impaired. Impairment is a concept which is fascinating, and that is if any of the legal, equitable, or other rights of the creditor are altered, however, they are impaired. Now, a horror story represented a secured creditor one time owed $10 or $12 million, secured by substantially all the debtor's assets. The debtor proposed a plan that was supported by two creditors. The unsecured creditors is doing horrible things to our client, the secured creditor, but it was paying the two unsecured creditors. The debtor's former lawyer and the debtor's former accountant were impaired. How were they impaired? They were paid in full 30 days after confirmation. That is impairment, and that was enough for the bankruptcy judge to confirm the plan. We had to appeal 3 times before we finally got that plan denied and unconfirmed on the strength of the debtors proposing the plan not in good faith. Next slide, please. Okay, in order to confirm a plan, you need to get consents of one class, at least one class of impaired creditors. You can't get consents until there's a disclosure statement that's approved. The plan is like a contract. The disclosure statement is like a stock prospectus. It tells you all kinds of stuff that mostly you don't care about that is supposed to provide adequate information. Now, some people believe that more words are more adequate, but other judges are of the opinion that it really depends on what the circumstances are of the debtor. And a disclosure statement for the PG&E plan is going to be remarkably different than the disclosure statement for the local mom and pop store at the corner. Next, please. Assuming that you got the disclosure statement approved, and then it goes out to creditors, and the creditors then vote on the plan, the judge sets a hearing on confirmation. In order to confirm the plan, the debtor has about 9 or 10 different boxes that it's got to check off, and the judge has to find that the debtor has satisfied each of these requirements. One of these requirements is good faith. We've already talked about that. Another one is that at least one class of impaired creditors has to vote in favor of the plan. Oh, by the way, the class votes, in order for the class to vote in favor of the plan, it has to have the majority in number of claims and 2/3 in dollar amount of the claims. So if there are 50 creditors that hold a total of $150,000 in claims, you have to get 26 creditors to vote in favor of the plan, and you have to have $100,001 of those claims to vote in favor of the plan in order to move toward confirmation. If there's a class of impaired creditors that hasn't accepted the plan, you then can try to cram the plan down on them. Next slide, please. Among the other conditions to a confirmation other than cram down, the court has to determine that it's in the best interest of creditors. Here's where the court does rough justice to essentially force a deal on creditors who are maybe not looking out for the best interest of everybody. A plan, in order to be confirmed, the creditor has to get more value than the creditor would get in a liquidation. It doesn't say how much more, and if it's just more, that's all you need. The other test that needs to be satisfied is the plan is feasible. You can propose a plan that says, I'm going to pay every creditor in full by winning the lottery. But that plan may not be feasible unless it's determined that there is a very high likelihood that, in fact, the debtor is going to win the lottery. And if that's the case, there may be good faith issues involved. Next slide, please. Okay, even if creditors are impaired and do not accept, then you move toward cram down. Cram down sounds like a pretty violent term, but what's wonderful is that the code uses the phrase, it has to be, quote, fair and equitable. Now that sounds like a reasonable term, but we're saying the same thing. In order to satisfy the fair and equitable standard of the bankruptcy code, the court has to decide that the plan can be crammed down on creditors. Next slide, please. Read. For a class of secured creditors, a plan is fair and equitable if the creditors get to keep their liens and the stream of payments are at least the value of their security interest. Alternatively, if the collateral is sold and the liens attached to the proceeds, or alternatively, and here's where you get creative, the secured creditors get the, quote, indubitable equivalent of the claim. I love that phrase. What is the indubitable equivalent of cash? one would suggest that the only indubitable, you have to be, it should be an undoubted equal. I'm old-fashioned. If the undoubted equal of cash seems to me to be only cash, but other courts have found otherwise. Next slide, please. As to unsecured creditors, the plan is fair and equitable, again, meaning they can cram down, if the creditors get paid in full, well, that's easy, or if no one junior to the creditor gets anything before the other senior creditors are paid in full. That's what's called the absolute priority rule. That just means if you remember those old lawn ornaments where there's a little tiny cup at the top with water that burbles out, and then when it reaches the lid, it flows to the next level. That's what you have to show, that the top cup gets full, and then anything above payment in full flows down to the next junior cup. Next slide, please. All right, what happens if the Chapter 11 case fails? You can get a trustee. Maybe the trustee can do better than the debtor in possession. You can convert the case to Chapter 7. Maybe that just means I give up. Let's call it a day. You could even get the case dismissed if there's nothing really left to do. Say the Chapter 11 plan fails because Chapter 11 case fails because the only asset is the secured creditor's collateral. The secured creditor's gotten relief from the automatic stay, and they have proceeded and foreclosed on the collateral. There's just nothing left to reorganize. So that's the three scenarios. You could either dismiss, trustee, or convert. Next, please. What's conversion in Chapter 7? This is when the business activity stops immediately. A Chapter 7 trustee is appointed immediately. The debtor, while they fill out the schedules and statement of affairs, essentially says, here are the keys, I'm out of here. I'm gone. Then the Chapter 7 trustee has the unenviable task of gathering the debtor's non-exempt assets together, liquidating those assets, finding the right price for them. They prosecute claims that the debtor may have, and they defend and attack claims that are aimed at the debtor. If the creditor files a claim for $100,000 and it really should have only been $1,000, the trustee would object to that claim and get it knocked down. And then after all that work is done, the trustee makes the theoretical distribution to creditors as their interests lie. I say theoretically because in the overwhelming number of Chapter 7 bankruptcy cases, the creditors get, the technical term is nothing on their claims. Next slide, please. That's it. I hope this was worthwhile, and thank you very much for sticking with us. And if you haven't seen The Wizard of Oz, it's a movie you should see. Thank you very much.